be speaking to you from Johannesburg. As mentioned, I am from ENS Africa, head of the TMT team. Two organizations which I've been privileged to have worked with is one is the United Nations Global Pulse Privacy Advisory Group. It's now known as the Data Governance and AI Group. And the second is I founded an organization called Privacy Officers Africa. I only mention this because in some of my examples, which I'll give, it's largely through the working with these organizations, as well as my own law practice. So if we look at the last year, I think there's some noticeable developments which have taken place. I think some countries long awaited their data privacy legislation started coming to the fore, and we look at countries, for example, Eswatini and a few other countries. So we are seeing more and more countries actually starting to adopt data privacy legislation or drafts thereof. Conversely, one of the other things which we're seeing is some countries are delaying implementation of data privacy legislation. Botswana is a good example where the date for the Botswana legislation being enacted has actually been pushed out. In Namibia, we're still waiting for the legislator to actually debate the draft data privacy legislation in place. In Zambia, the compliance period for legislation is put out until 1 January 2025. So in as much as we're seeing some countries starting to adopt legislation, we're also seeing others starting to delay implementation of legislation. That's for a number of reasons. I think some of the other noticeable trends which we've looked at over this past year is there seems to be a lot more regulatory activity. So we're finally starting to see regulators in certain countries starting to take action and starting to show their teeth when it comes to enforcement. In South Africa, this year we've had two instances where the regulator actually, one issued their first fine. Curiously enough, the fine was against the Department of Justice, and jokingly we state that that was nothing more than a very expensive accounting exercise because the regulator themselves form part of the Department of Justice. We also saw enforcement action being taken against one of the large pharmaceutical retailers in South Africa, and there the regulator was more prescriptive as to certain types of security protocols that the retailer needs to adopt, etc. We do, through the grapevine here, that judgment or that enforcement notice is probably going to be taken on review. So we're starting to see some regulators starting to bear teeth. I think the general overall experience, though, has been that many regulators are still finding their feet. There's still a lot of capacity building within regulators. There's still a lot of, I think, I don't know if it's lack of political will, lack of financing, or just fear of the unknown. So some regulators are still taking a step back and waiting for further developments before they start taking action. And that's been quite noticeable. Other noticeable trends which we've picked up working with clients, especially we work with a lot of multinationals and also South African companies moving across the continent, or companies in other parts of the continent moving in different directions. And one of the single biggest frustrations is this very disparate landscape when it comes to data protection. And what we're not seeing is greater harmonization of standards. Although if we look at in Southern Africa, I took a look at the draft Namibia legislation the other day, the Botswana legislation. They're not too dissimilar in their operations, but there still are some material differences. And it's not a question of a company wanting to expand their operations across the continent or in a certain region in the continent, where if you're compliant in one jurisdiction, you virtually can be assured that you're compliant in a number of other jurisdictions. There still are significant nuances, and that's becoming quite noticeable as well. So those are just some of the trends that we're picking up. I think the other single biggest trend, and this is where my view data privacy legislation globally, not just in Africa, falls short, is that it touches on cybersecurity without going into that much detail. So regulators around the world have been fining companies for not implementing proper cybersecurity requirements and the like. But what we're not seeing, and what I'm not seeing, certainly from a South African perspective and from some of the other countries which I've worked in across the continent, is regulators actually taking the approach to advise organizations to say, if you are, for example, in a specific sector, this is the minimum type of security you should have in place. In some industries like banking, we are seeing the local regulators starting to become more prescriptive as to the type of security that should be put in place. But there's still this tussle between, on the one hand, privacy and access to information, and on the other hand, cybersecurity. And because the regulatory landscape seems to be quite disparate, and there's a number of pieces of legislation which impact on both areas. Ultimately, though, it's the information regulators who usually will be the ones levying fines and the like. So that's another area which we find that it's very frustrating for a lot of our clients moving into the continent, across the continent, that they're finding that on the one hand, you focus on privacy, you focus on access to information, but then you've got a whole set of other requirements in certain sectors around cybersecurity, and more worryingly, in certain sectors, there's nothing around cybersecurity apart from privacy legislation actually stating that you should be putting in place reasonable technical and organizational measures, or something quite loose in wording, without being more prescriptive. It does raise the whole other debate is, should legislation ever be, or should legislation keep being technology neutral, or should regulators start becoming more prescriptive? I think for certain industries, regulators need to become more and more prescriptive, especially if you look at the financial services industry, the telecommunications industry, the large retailers, the large e-commerce and platform players, those companies that deal with vast amounts of data. There needs to be some form of minimum standards being imposed, and those standards need to be drafted in a flexible enough manner that it can be adapted to respond to new threats or growing threats in the cybersecurity landscape. So that's another area, and I think cybersecurity, and I'm probably preempting a question which is coming up, but looking forward to the new year and beyond, I think cybersecurity is going to be probably the single biggest focus area for most organizations in Africa and globally as well.
Wow, thank you so much. I think your opening remarks really capture a lot that has been happening in the data protection landscape in the continent. And I particularly love your reference to the growing issue of cybersecurity and its interaction to data protection. And if at all any region acknowledges the importance of having prescriptive guidelines on cybersecurity and their relation to data protection, would be South Africa, because, and I think you also made reference to the Department of Justice decision. So, and I think we also mentioned the DISCAM, and we'll come back to that, because one of the things that you mentioned about you have really emphasized a lot on having prescriptive guidelines. I'm actually looking forward to engaging you on that, and how you think about that, or rather how you think that should be carried on forward in the coming year. So thank you so much for that. So Ilamosi, I'd also want to share with us what really stood out for you this year. Why was it significant? And yeah, please take over.
Thank you so much, Mercy. Just like Ridwan said, enforcement was a very big thing this year. I found it particularly interesting that he mentioned the South African DOJ fiasco, because I was going to mention that as well. I thought it was interesting, that the South African Data Protection Authority was enforcing or carrying out enforcement actions against government, which I think is good. Apart from the DOJ decision, there was also an enforcement action against the police for, I think, a leak of data that was involved in an investigation. So I think that that's really interesting. And if other countries pick up on that, I think that that's something that could be very good for the ecosystem generally. So I just wanted to mention enforcement generally and highlight that. The second big trend that I've noticed that maybe everyone did not mention is that there's a budding interest in child protection and creating age-appropriate experiences for children within the region. So, for example, the Mali DPA issued a public notice, just urging mothers and children on how better to protect their data online. I know that Senegal, there's a case there. I know that in Nigeria, there's, similar education action, same thing in South Africa. So I think that that's another big thing that another big trend that I noticed this year. Just to add, I mean, I'm sure everybody knows this, but a lot of new DPAs were created this year, a lot of new laws were created this year. So we're seeing more registration requirements, we're getting maybe slightly more clarity around laws. I'm seeing that subsidiary legislation is being passed or is being created, just to flesh out the laws and to make people understand what the processes and procedures are. So those are sort of the big trends that I observed this year as regards the region.
Yeah, just before I let you go, I think kindly, if you could explain for us, you mentioned something about more what I'd refer to as sectoral guidelines on data protection and privacy that have been happening around, I think it's actually around the continent. In East Africa, we've had several. You mentioned a few in East Africa. What do you think is the significance of this, especially to businesses in their compliance processes?
Well, the sectoral guidelines I think are good in that, and by sectoral guidelines, do you mean the sub-regional guidelines, or do you mean the ones that are being passed by individual countries? Just to be clear.
Yeah, just for individual countries in
Okay. No. It's definitely good. It gives some clarity to businesses going forward in regards to specific provisions in data protection laws. I think that's a very good development. I think it can only provide clarity, to be honest. I don't think there are any downsides to it. I think that, though, the one thing I want to flag is that maybe it would be good if the DPAs work more with the private sector, because even after these laws come out, we see that there are instances where the laws don't exactly fit what's going on in the business area. We see that there's a mismatch somewhere. So it would be good if there was more co-creation of these laws, or there was more consultation going on with these laws. That's one thing I will flag. But generally, having more clarity is always good. And I don't think that it can negatively affect the businesses, getting that additional clarity.
Couldn't agree more. Catherine, if you could take us also through what stood out for you in your area of practice in East Africa, what do you think stood out for you, and why was it significant for you?
Thank you, Mercy. Thank you for inviting me. I'm glad to be here and to be part of the panel. Just to add on, my comments are going to build on to what everyone else has covered. So maybe the aspect that I'd add on what has my general overview for this year and what has stood out for me from a policy perspective, because apart from my law firm work, I work in a law firm, I'm in a TMT department where I do a lot of data protection and privacy work, but I also work a lot on policy work. I work with an organization also called Africa Privacy and Legal. So because of that, I get to follow a lot of, from a policy perspective, what's going on around Africa. So for me, what has stood out this year from a policy perspective, one was the Malabo Convention's implementation. This year saw the 15th signatory sign, which means it came into effect. I think Mauritania was the 15th country. So then the Malabo Convention, which was signed up, which was passed in 2014, we saw it come to fruition this year. And that's a big deal for us, because then there was always the gap for the Malabo Convention, which is also called the AU Convention on Cybersecurity and Personal Data Protection, has been passed, but not quite. There was always that thing of not quite. We still need the minimum mark of 15 signatories. So I think it was signed on in May, came into effect in June. And for me, that's a big deal for the continent as a whole, because then what this meant, and then in September of this year still, then we saw the AU become a permanent member of G20, which again, if you think about it, it's a big deal, because then it means it gives us power as a region. And AU, because one of the things in the data protection space, I think that we used to talk about is the various states operating in silos, and us needing a very sort of a framework that brings us all together and where we can deal with data protection and privacy, trade barriers from a regional perspective. We've always said, why can't we have an EU approach as Africa? So then for me, the highlight in September, where Africa Union joined G20, was a big deal. I think last year we saw AU released what we call the AU Data Protection policy framework. That was in 2022. But what it meant in 2023, part of the recommendations were in the data policy framework, I think, was that for a regional approach to data protection and privacy, and it said part of the recommendations were, why can't data protection authorities come together and really remove the siloed effect to approach in data protection, regulation, and privacy. And one of the things that we've seen, I think this year, we've seen a lot of activity on data protection authorities trying to see to that. I know for sure, at least from the East Africa region, Mercy, if you've been following that, there's been a lot of activity from Kenya, Tanzania, Uganda, where they are trying from a regional perspective. Our regulators are trying to coordinate in the back end, and that will make all the difference from a trade barriers perspective, where now issues like transfer of data, which we grapple with within Africa, where for those of us who work in law firms and advise clients, we know it's always a headache, as Ridwan has mentioned, when they're trying to expand across Africa, and you literally have to tick off the regulatory exercise and the compliance exercise in the different states where your client is expanding to. So then that's one of the things which for me stood out, and I can only hope that 2024, it's also part of my prediction for 2024 that we'll see better coordination and we'll do better. So I think and then if you go and check the other recommendations on the AU data protection policy framework, the other things that one of the things in fact that they had highlighted is why Africa Union can't take the EU approach, which they provided that in 2022 and it's coming to fruition in 2023. So for me, I see more and more of their recommendations being implemented. And I like the fact that the approach is from an AU perspective, which means it's a regional perspective. And therefore, the conversations we have now are more centralized and the approaches that we have are more centralized. Just like they've said, an action of more data protection laws, with more people joining countries that have data protection laws. I think Nigeria was this year as well. For me, the other highlight, as they said, was the bold moves by the data protection authorities. And especially within East Africa and Kenya, we've also had the judiciary join in that. We've had judicial developments and pronouncements that are quite bold in the data protection space. And therefore, we've been getting, we're getting more precedents, I would say, which for me is such a highlight.
Wow. Thank you so much, Catherine. I think just your last statement on the growing number of enforcement decisions and their importance, is a resounding reminder of, data protection is growing in Africa. And to just conclude this final question, because I needed all of us to at least address this initial question, because we have different experiences in different regions. I will conclude with Maha. Maha is a data protection expert, particularly well-versed with what's happening in North Africa. So Maha, what stood out for you this year in terms of data protection?
Thank you. Thank you for having me on board. Thank you for my fellow African expert. Sorry, I have flu. Yes. For instance, in Tunisia, as you know, my country was the first country which launched the National Authority for the Protection of Personal Data, ENPDP, in 2009. After the designation of its members in 2008. Later on, after the revolution in Tunisia, 2011, as you know, the ENDP start to work and so on. However, the only issue which we had with the data protection laws is the lack of democracy. And there are other laws which we don't understand it as Arab, like for example, we do have the law in the constitution in the constitution of 2014, which says that the government prohibits any act of touching to sacred. So according to that flu laws, many bloggers and experts were caught and were arrested, and many platforms were stopped from working because the constitution doesn't define for you which is the sacred. How can I define sacred information? This is the first thing. The second thing, the country signed the convention of 108 plus. You know it, like it was signed on 2019. And also last July, Tunisia celebrated the launch of the very first practical guide to personal data protection dedicated to the insurance sector, which is good. However, since the coup d'etat 2 years ago, which is a trend in North African countries and many Francophone countries, so the ENDP is stopped from working because there were a coup d'etat, so all of the protection laws or national instance were stopped because we are in the process of new laws, of new governments, and so on. And during that process, we don't have any access to get informations from ENDP or from whatever instance working on digital rights or on personal data. Well, according to the Tunisian law, the personal data means all information, whatever its origins or form, which directly or indirectly allows a natural person to be identified or makes them identifiable, with the exceptions of information linked to public life or considered as such. Also, we have special categories of data, which by their nature may place the data subjects at risk when they are processed, and therefore require and increase the protections. So we have like four categories of data. And if you go to the platform of ENDP, I'm going to share with you the link. You will get more information about processing data and so on. This is wonderful. This is good written laws. However, as long as we are under coup d'etat since 2 years, so the government allows to itself under the protections of the civil peace or under the what they call it protecting the national sovereignty. They allow they give to themselves the rights to interfere your personal data and broke your privacy. And this is happening in most of the Arab country. So today, for me, if I have a recommendation, is to consider the democracy, the right of privacy, and also consider the development of technology in the country. I give you an example. For example, in Mauritania, you have mentioned Mauritania in your presentations. In Mauritania, Tunisia, Egypt, there are many tech entrepreneurs and businessmen. They buy their server and put their information out of their countries because there are no law of protection. Moreover, they don't trust the democratic process in the country. I'm sorry because I get into policy and democracy because generally and unfortunately we don't highlight this dimension because we always think that this dimension belongs only to human rights defender, but however, it's affecting everyone, whether you are in the private sector or a governmental sector. Yeah, sorry.
Yeah, No, do not apologize, Maha, because your intervention is really important because it sums up what are the influences, because what we see at the end of the day are laws. But laws, as you clearly are mentioning, are a product of societal functions, some of them political. Therefore, your intervention really is, I agree, it's a very important one and summarizes for us what has been happening around the continent. So maybe just to move to the other question and sort of touches on what we have been discussing, at least for the last half hour, is from your perspective, and I'll ask all of you to just give a 2-minute intervention on this one, is we have spoken about what really stood out for us, at least in this year. What do you think did not materialize? And in terms of what did not materialize, I think it'd be good to couple it with which of the data protection authorities in the continent stood out for you, and why you think their work really stood out for you this year. So I'll start again with you, Ridwan.
Okay, things that did not materialize. I think, as I mentioned, one of the trends which I've noticed is certain governments actually deferring their legislation or implementation of legislation. So Botswana is a very good example. We were expecting their privacy law to come into force imminently. Namibia, it's been going back and forth in various legislative processes. So certain countries, they still are no laws, and by now we would have expected that at least there would be a framework of laws, if not a functioning regulator. The other things which I've noticed is that although regulators are slowly starting to take action, we're still not seeing enough being done on the part of regulators. And I think I speak as a commercial lawyer. One of the definitive trends that a lot of our clients tell us is that until you don't have a regulator that has teeth, we're not going to worry too much about complying with laws. I know it's a terrible thing to say, but in South Africa, for example, companies are burdened with well over 100 laws within which they need to comply with. So even a small little business needs to comply with a whole myriad of laws. And sometimes whether you're a big business, a small business, all of these laws, compliance comes at an expense. And a lot of our clients are telling us until we don't see a regulator with proper teeth, we're not going to really worry about this law. And we were hoping to see a lot more action being taken by regulators. The other thing which we didn't see happening much, and I'm not surprised at this development, is regulators not doing anything about artificial intelligence. I recall back in 2019, working through my work with the United Nations, working with the information regulator of Ghana and the information regulators of Uganda, trying to put in place some form of artificial intelligence framework. And that, as far back as 2019, proved to be very difficult to do. To date, I'm not aware of any regulator, certainly in Southern Africa, that is doing anything proactive about regulating artificial intelligence. It has caught a lot of people by surprise this year, just the rate at which AI became mainstream. AI is nothing new. I mean, I've been part of the UN's AI expert group since probably the last 8 years or so. So AI is not new, but ChatGPT has caught a lot of people off guard, brought AI into the mainstream. But one of the things which I'm very surprised, I haven't seen any regulators, certainly in Southern Africa, actually put in place any form of protocol or intervention or guidelines around AI usage. It could be a case of wait and see. Let's see what the rest of the world is doing. Then we'll take a step back. But I do think that regulators have known about this for a long time, and rather than always waiting for Europe to do something and then us piggybacking off what they've done, I think this was a prime opportunity for certain African regulators to have taken a lead. So I'll end my section there. Thanks.
Thank you so much. Maha, I see your hand is raised.
Yes. Yeah, thank you. Thank you, Mr. Radwan, for mentioning the AI policy and AI ethics framework in the continent. Actually, in September 2022, there were the Windhoek Proclamation for AI ethics, which was launched in Namibia and supported by the whole of the Southern African countries. However, the
Did we lose Maha? Okay. Okay. In the meantime, maybe Catherine could give us your intervention on what do you think we missed out, and why is it significant for you, and which DPA stood out for you?
I think for me, I agree. I agree with what Ridwan has pointed out on the trends. Obviously, emerging technologies was a big thing because of how closely connected it is with data protection and privacy, and how central data protection and privacy is. So I agree with you. I don't feel like the authorities quite demonstrated that, even if not to the level of perfection on embracing or being able to deal with these emerging technologies, they did not demonstrate some form of like willingness. Like what I've seen in terms of regulatory mindset in other sectors is where, for instance, they roll out the sandboxes or collaborative efforts with those rolling out these emerging technologies just to be able to understand them. Because I mean, obviously there's the analogy that you can't regulate what you don't understand. But I believe from around Africa, yes, we haven't seen that demonstration of where regulators are even interested in sort of like understanding these technologies before attempting to sort of like regulate, even if not regulate, guide around these emerging technologies. I haven't seen that as well, and I agree with you. Then something else that I expected that did not materialize is still around the regional cooperation. I expected us to make bigger strides, so to speak. I expected that this was the year that at least all countries that have data protection authorities would have figured out the regional cooperation aspect. If at all, from a regional basis, where we would see, say, like the East Africa community would do something, and then the various regional blocks would now do something in the back end. Or I also expected that the AU would coordinate this exercise and push it. I didn't see that. I expected to see also the AU putting in a lot of work when it comes to awareness around data protection and privacy, knowing the nuances that affect Africa as a region in terms of literacy and things like that. So I expected that, and it's also my hope that we can predict that in the next year, now, especially with the Malabo Convention and with the G20 aspect, that now, hopefully, that's what is going to happen in the next year. And I mentioned this because when you map out what the different data protection authorities are doing in the different countries, you see a sheer replication. Like everybody is doing the same thing only in a siloed way. And then what you ask yourself is, surely, why does this need to happen? Why does a data protection authority need to reinvent what someone else has done so well, say in another region? So for me, that's something that I expected that did not materialize. I expected to see a lot of data protection authorities making governments accountable and save, like, for example, for the South African case that Ridwan has told us, I haven't seen anything else. And I feel, especially like in Kenya, this has been tested, and I feel like our data protection authority did not flex enough. Obviously, there hasn't been there's element of independence. There's always a question of independence, since most data protection authorities are housed and financed by government structures, and therefore there's an element of how do you punish yourself, or the analogy that Ridwan had provided. So then I expected that this year they would demonstrate a bit more independence, so to speak, where the government agencies are also made aware that they're also supposed to comply with the data protection laws, the local laws, especially in nations. I see more and more countries within Africa, from a public perspective, digitizing more. So for instance, in Kenya, we have most of our public services are now accessible digitally. So government has rolled out an initiative where it intends to house, I think, over 5,000 services digitally. accessible. So I expected them to be, the government to be made more accountable. For instance, we had a case where in Kenya, the judiciary said that government should have carried out DPIA on registration, individual registration system that they wanted to roll out. But I haven't seen the authorities flex in the different countries. And that's for me, while they've really put in check what I'd call the private or the commercial side of things, they haven't really done that to governments. And that's something that didn't materialize for me. I think, and then I've mentioned, and I've mentioned the cross-border cooperation. Mercy, for me, I think those are the highlights in addition to what Ridwan pointed out. I agree 100%.
Thank you so much, Catherine. So Ilamosi, just briefly, what do you think did not materialize?
I'll try and keep this as brief as possible because Ridwan and Catherine have already mentioned key points. Something I wanted to say that I noticed did not materialize, a trend I noticed did not materialize was localization. Last year, as at December, I thought localization was going to be the main topic this year. I was fully expecting a lot of regulation. I was expecting enforcement action. I was expecting a lot of things as regards localization. And we're in December, and I haven't heard a peep. So localization was a topic I thought was going to be very big this year. I also thought, just like Catherine mentioned, that there was going to be more harmonization this year. The AFCFTA, there was a lot of work going around that and a lot of discussions that were going on at the beginning of the year on, its lack of data protection, a proper data protection framework and how, that was going to be developed. So I was hoping that based on that, and even when the Malabo Convention received its 15th ratification, I was hoping that those two factors would sort of spur more, a better, more advanced conversation on harmonization or uniformity in the region as regards data protection. But that did not materialize. And just to answer the second part of your question very quickly, so I didn't take so much time. Contrary to what Catherine said, the DPA that actually stood out for me this year was actually the Kenyan Data Protection Authority, and it was for one specific thing, the WorldCoin issue. I thought that, based on where we are and based on how these things typically go, I think that they handled that pretty well. Like the enforcement action was very quick. Turnaround time was also very quick. They got an injunction against them at the High Court. The Parliament also set up an ad hoc committee to investigate and then give, comments or a decision on it. And then they did their own independent enforcement action. So that's something that, I thought was very good. It was like on all fronts that they could cover the issue was covered. Typically, where we see data protection authorities carry out enforcement actions, they give an enforcement notice, maybe followed by a fine, but they went to court. All the steps that I think should have been taken were taken. So I think that that's something I wanted to just quickly give them props for. And if I could very quickly comment on the AI issue that was also raised. I think that yes, AI was expected to be a big thing this year, but one of my predictions for next year is that AI is going to be the main topic for next year, because all the conversations I've been in, all the rooms I've been in for the ending of this year, because of ChatGPT, like you mentioned. And because AI is now a hot topic around the world, the EU AI Act was recently passed, and everybody knows that in this part of the world, if the EU does something, regulators are like a step or two behind. So I'm fully expecting that there will be more AI regulation next year. There will be more conversations about AI or regarding AI next year. Those are just the things that I wanted to quickly flag.
Wow, thank you so much. And I think that creates a really good segue into AI discussion because, well, not really AI discussion is because I think one of the common themes around what I've had all of you mention is on the issue of emerging technologies. And if we can agree, one of the emerging technologies that has taken center stage, at least this year, is AI, several interventions, and has very close links to discussions on privacy and data protection. We've seen earlier this year several data protection authorities from around the world, including, I think, from Morocco or Tunisia, releasing a statement on the issue of data scraping and the need to ensure that data scraping respects the right to privacy of a person, or rather personal data that is used, of the data that's used to train these machine learning models. So just to start off with you, Maha. Oh, sorry. Oh yes, yes. So I think you can introduce us into the issue of AI, given your expertise and the work that you're currently doing on the global index on responsible AI. So take it over.
Thank you, thank you. I'm based in Senegal, and as you know, the Senegal launched the AI national strategy towards 2028 last 14 September, which is which was based on AI as a locomotive for prosperity of Senegal and for the raise of the Senegal economy, which I think it's very close to what Egypt launched last year, AI for prosperity and AI as a tool to raise the economy and well-being. However, the two countries, they still have lack on, first of all, regulatory frameworks, because still now there were not yet any clear or supportive legal framework on terms of AI governance and ethical use. Because if we talk about Egypt, in Egypt, there are 254
Maha, I think maybe she's having connectivity issues. Maybe just to save on the little time that we have left, maybe Ilamusi, sorry to take you over, but in terms of potential breakthroughs in technology and policy that you think could significantly impact data protection, what do you think these are?
Okay, so I'm going to start with maybe policy first. The Malabar Convention is a big one. I'm hoping that next year it would lead to, some sort of change, because, with the convention, once it is enacted, then all the state parties who are signatories to it have to make sure that their data protection laws are in compliance with the convention. So I'm hoping that maybe that would drive more uniformity or more harmonization across the region generally. I'm also hoping that the AFCFTA will see more work on that, which will also push harmonization. Like I mentioned earlier, I'm sure that there's going to be more AI regulation next year. I know that various countries are already developing frameworks to regulate AI. I know Nigeria is doing that, a couple of other countries within the region too. So I'm fully expecting that next year we'll see more AI regulation within the continent. I'm also expecting more enforcement. Enforcement is a trend that we noticed this year as increasing, but I'm also expecting that next year we'll see even more enforcement. Like I mentioned earlier, there are new data protection authorities, some of which have been set up, fully established now. We're seeing that, the laws are being created and even sub-regulation is also being created. So I'm fully expecting that next year, based on what we've seen this year, the countries, the data protection authorities that are already, carrying out enforcement action will increase in their enforcement action. That's something I foresee. And those who haven't already started will begin. For various reasons, including, data protection generally by itself for the security of the citizens' data, but also because, I think there's a revenue drive that's sort of going on in different countries across the region. And so that's a very good way to generate government revenue. I'm also predicting that, consent might be a bigger issue in the next year. I've seen a few things that have just given me clues about this. I know that in Nigeria, there are various actions now as regards consent. In Kenya, very similar consent. South Africa, consent is also a very big thing there. So I think that we're going to see a push for consent as maybe the primary basis for data processing. I don't know, but that's what I'm predicting is going to happen next year, because I've seen it's popped up severally, even when there are other legal bases, consent is repeatedly mentioned and somehow puts in front as the sole basis. So that's something I'm predicting for next year.
Wow, thank you. You answered like 2 questions, so thank you so much. Catherine, you also mentioned about AI as an emerging technology and the role that data protection could play. So what do you think are, maybe just to build on your previous point, because I see Maha has joined back, before I go back to Maha, what do you think are the potential breakthroughs that could see in terms of technology that could impact data protection? And feel free to even go beyond AI if you think there's more to it.
Yeah. I think for me, yes, there is the AI aspect. Sorry, excuse me. And I would add and encompass the whole emerging technologies aspect, because then because of how quickly or how fast, I guess, technology keeps disrupting, this emerging technologies keep disrupting the digital world or the digital space. I think the thing is, we don't know what else will come up. So for instance, in Kenya, the conversation that our financial services regulator is grappling with is digital currencies, crypto, blockchain, and they keep issuing out this regulatory sort of like buyer beware statement where they're like, we don't understand it yet, but we know it's out there. So then, as they've mentioned, and I agree with Lamosi and Ridwan, the nature of AI keeps progressing. And I think one of the things that I'd like to point out that I see in some data protection laws is lacking is the regulatory mindset, where it's reflected in the law itself. So for instance, like in Kenya, our Data Protection Act addresses automated processing. And if you think about automated processing, then AI and those other emerging technologies will be there. Well, you'll find there are data protection laws that are quite silent about that. So then my approach is always, if the regulator can provide for some of these things, sometimes you can provide for the unknown, especially in the technology perspective. And then one thing that we've been seeing in the Kenyan landscape is where a regulator keeps issuing out guidance notes. So you see, automated processing is already in the act, but then what they do is when they find that there's something new that obviously is central to the Data Protection Act and regulations, they provide these guidance notes or elaborations on that. So then that's something which I hope we can see more of from all data protection authorities. And because given the way the data protection and privacy spaces, it's always been pushed to new boundaries. And like Ilamosi has mentioned, the issue of consent, how we viewed consent, for instance, for the Data Protection Act in Kenya was enacted in 3 or 4 years ago. How consent was viewed then is not how consent was viewed now. And actually, to your point, Ilamosi, on the case that you mentioned, the WorldCoin case, where the controller argued that they had gotten consent, but the conclusion at the end of the day, it wasn't valid consent. So then it keeps evolving, it keeps emerging. I think this space is calling for regulators that are quite agile and regulators that have an attitude of more of collaboration than policing. It can't be that your work is policing and things like that. So that's my take on emerging technologies, and also what I expect to see, or the challenge to this space. And hopefully also, because further to Ilamosi's point, or if the AU can take this up, it would be more centralized and harmonized. And the guidance, and it would prevent, obviously, the siloed approach that we talked about. So this is one of those things, cybersecurity, data protection, emerging technologies, if we can approach it from a very centralized point, and hopefully maybe even have our own Africa Union AI Act, just like the EU is trying to do. Obviously, that would be something that that could be, or we pass a resolution that for emerging technologies we'll always take on guidance from the AU. I think that would make a whole lot of difference.
Wow. Thank you so much, Catherine. I think your sentiments are echoed with in a lot of policy initiatives that are happening already in the continent. Because I'm pretty sure most of us are aware that the draft continental AI strategy is in the works. And maybe just to finish up with you, Ridwan, what do you think about such initiatives? What do they mean for data protection in the continent?
Sure. So, I mean, I think such initiatives are worthwhile, provided that they get implemented and adopted by member states. The one thing I've noticed with AI, as with data privacy, is that there are a whole myriad of organizations across the globe trying to come up with their own set of rules around AI. I mean, I'm part, for example, of the International Technology Lawyers Association. I'm part of the United Nations Data Governance and AI Expert Group. I am part of Privacy Officers Africa. I'm a South African commercial lawyer working in the technology sector. And I can tell you from my experience, there are every single one of these organizations, plus literally hundreds more, all trying to come up with their own set of rules around AI. So I think having a common standard that is critical, whether that will actually materialize, I don't know. I'm not personally confident about that. I think the continent had a number of opportunities. Then data privacy was a great opportunity to have a harmonized set of laws, and it didn't adopt that approach. AI probably not too dissimilar. I think a lot of countries still are very focused on what's happening within their own borders. They're not really concerned about anything else happening elsewhere. So personally, I'm not optimistic. I think it's great that these initiatives are taking place. But ultimately, we'll need to see whether this translates into anything meaningful. Because the one, my single biggest frustration is there's so many organizations all doing the exact same thing, all trying to come up with the exact, or all with the same good intent to, come up with a set of common standards or laws which will be acceptable, and they still can't. That it still doesn't seem to be agreement. Even in the EU, for example, when the EU AI Act, the first draft, one of the drafts were published. The tech companies were absolutely up in arms about it, to say this is going to stifle innovation, and this is going to put Europe behind the rest of the world. So in whatever we decide to develop as Africans for Africa, I think there's always a fine line to be struck between trying to put in place regulation to protect our citizens and our people, but at the same time not stifling innovation, because that the single biggest inhibitor to innovation is overregulation. And I would hate to see a nanny state type of attitude adopted when it comes to regulation of AI, or for that matter any technology. Also, one of the things which is very noticeable, and I speak from my own experience in South Africa, is that law and technology never keep up with each other. So a government will put in place a law, technology surpasses it in a matter of sometimes a month, sometimes even by the time the law is enacted, technology would have surpassed it. And the law doesn't then play catch up. So agile regulation and lawmaking, that's something that governments need to start thinking about. How do we fix this problem? Because, on the one hand, you need a country which has laws, or countries where there's certainty in the law. On the other hand, you have technology which is advancing so rapidly that in the absence of some form of governmental intervention, it could have the potential to create real harms to citizens. So how do we strike that balance? I wish I knew the answer to that. I think if I did, I'd be sitting on my yacht somewhere off the coast of Cape Town right now, not in my office. So looking from an African perspective, the initiatives taking place are noble. Whether that will ever translate into anything meaningful at state level remains to be seen. Personally, I'm not confident, just based on our past history. But I don't know, maybe I'm just pessimistic. I'm sure others may have a contrary view to mine.
I think your intervention really balances off the optimism that maybe be there with a bit of caution. I think I wouldn't call it entire pessimism. I think moving with caution is what is ideal. So just to maybe move into the practical side of things, because I see Maha hasn't joined back yet. I would have really loved to hear what they are working on the Global Index on Responsible AI, given she is a country representative. But we'll move on. Hopefully she joins back. So maybe to also, as I mentioned, to move to the practical side of things, we have really spoken a lot about, so in our different interventions, we hinted at the need for harmonization, the need for cross-border cooperation. All these things eventually tie to businesses and how they can properly operate in the continent, while also promoting data protection, right? So what, in your opinion or in your view, do you think businesses can do to ensure compliance in this evolving legal landscape? So I'll start with you, Catherine, while maybe you share your views, and then we'll move to Lamusi and then Ridwan.
Okay, I think I'll start with the most non-obvious, which many businesses don't think about, but it is influencing policy. Businesses must start getting together to influence policy, because then policy informs everything. Policy informs laws. And that's one thing which, at least within the East African market, we haven't seen, but it's gaining trend. And I think Africa-wide, if they were able to push for that, for instance, I think it's one who mentioned the ACFTA, or Ilamosi. I think all of us keep mentioning the ACFTA, and if you read the ACFTA, the benefits that are bound to come out of successful implementation of ACFTA to the businesses or to the business environment or to the trade environment are enormous. So if at all from our different angles or from our different jurisdictions, businesses are able to push for policy changes, are able to push their countries to push for implementation of ACFTA, it would make all the difference, because then it means it brings down the trade barriers. Doing business across Africa would be easier. I think more and more we are seeing jurisdictions where, for instance, in Kenya, where a telecom company like Safaricom becomes huge and wants to expand across Africa, then you'll find there's another South African country that's good in something else and wants to expand across Africa. Then you'll find there's a Ghanaian company that also is good in another industry and wants to expand across Africa, but they all encounter the same barriers. So it's about time they started changing that. So saying that, before that happens, obviously all businesses need to keep up with the emerging trends, emerging technologies, how disruption. I think one of the main things that we point out to them is when they're coining out their strategies need to have one of their pillars as emerging technologies and how they're going to affect the business. And this will enable them to be able to predict and also position themselves, because one of the things that we've seen is disruptions are what you call a double-edged sword. I mean, it can be a good thing, it can be an opportunity for you, but it can also bring you down in terms of business. So I guess it's positioning yourself, figuring out what are the predictions, how will they affect the business. For instance, I think one of the trends that we've seen this year is many businesses embracing harnessing AI. We've seen a lot of that, harnessing AI in their businesses to obviously harness efficiencies. But I think one of the things that we saw not across Africa, but even globally, is the companies, for instance, embraced ChatGPT initially, and it came out later that trade secrets, the risks, they found out the risks later, trade secrets, employees were using it, the ChatGPTs were hallucinating, and therefore the research was faulty and things like that. And many companies now, I know some companies that went ahead and came up with policies that they told their employees that if you're going to be doing research work or whatever work it is, you cannot use these technologies like ChatGPT because of the risk involved. Well, if it was part of the pillars and they had a team that keeps tracking and also, I guess, figuring out how it impacts the business, they would have been able to position themselves to harness this and also to be able to realize the potential risks or pitfalls of such technologies. So I think one of the things that I would highlight is keeping up with the trends, but not just keeping up, but also figuring out how they work for you or against you. The final thing that I'd like to highlight is collaboration with the regulators. The mindset has to change. We've seen a lot more of this, which really works where, say, businesses keep, if you're rolling out a product and you're not sure about it, then you engage the regulator. At least in the Kenyan space, I've seen a lot of that, and it's also helped change the regulatory mindset where you're not self-reporting, but you can approach the regulator and say, we have this is different. We haven't done this before. How would you guide us? How would you want us to proceed? And I've seen that working well, because what it does is doesn't stifle innovation. You're still able to roll out. And when you roll out, the regulator is not after you, flagging you and issuing all these penalties because the effort was done jointly. I've seen a lot of that happen within East Africa, and I see it working and benefiting the business sectors as well. So what I've seen is the mindset of the in-house policy, and I think government affairs as well as the legal teams change their approach of how they used to do things, so that it's just not a checklist or a tick box items. They're being asked to be more proactive in terms of the regulatory engagement and in terms of how to do things. And yeah, so that's what I would highlight, Mercy. Maybe I'd like to hear what Ilamosi and Ridwan have to add on to this.
Ilamosi, please.
Yes, thank you so much, Catherine. I completely agree with you. My first 2 points that I was going to make are very similar to what you said. The first thing I had was get familiar with data protection laws. I think that more businesses need to know what the law says and how to comply. The second thing I was going to say is that they should get involved in the lawmaking process and policy making processes. Send in comments whenever comments are being called for, assess the laws critically, and if you have any concerns, focus on collaborating with the local data protection authorities to just make sure that your comments are addressed in the best way possible. The third thing I would add, which is fairly obvious, is get a data protection officer, and ensure compliance with the laws as much as possible. I would also suggest that businesses implement data privacy management systems within their organization, just to ensure that data, even employee data, is properly stored, properly disposed of, properly used where applicable. And then the last thing I would say, and this is more for, tech companies, I think, or people who are building products, is that businesses should try and implement privacy by design and default within their products and their services. It helps with compliance long term, even if your regulator maybe hasn't caught up with what the current practices are, international best practices are. If you have that within your business framework, and other businesses have it too, there are two ways, in my opinion, of making laws as regards whenever policy is involved. It's either government makes the policy and then businesses conform to that, or there's already an agreed upon policy, like amongst business practice amongst businesses. So if everybody is doing it, when government is making the law, it will be very unwise of them to bring in a completely new system. So that's another way of also influencing policy. If you incorporate international best practices within your products, within your systems, then government sort of has to comply. That's like a secret. But yeah, those are the tips I have for businesses.
I really hope the businesses here listening. Ridwan, please.
Thank you. I echo everything that Catherine Ilamosi has said. I think really, really great tips, and I made a note of some of those mentally for myself as well. But I think some other interventions which businesses should be making. Number one, when you are expanding into different countries, into in whether it's Africa or beyond, in fact, understand the regulatory environment, understand the nuances, understand what the local requirements are, and that that means heavy reliance on local counsel and local expertise, because me sitting in South Africa, it's all well and good. I can tell you what's happening in Ghana and Kenya, but I'm not an expert in any of those laws. So you'll need to rely on local counsel to give you the real insights. I think that the Italians have a saying, there's two types of lawyers, the one who knows the law and one who knows the judge. So having someone on the ground who knows the regulator, that's also critically of importance, because it helps with getting those decisions fast-tracked, helps with having discussions with regulators or getting access to regulators and like. So that would be my first tips. Other tips, I think there's, and I speak as a commercial lawyer now, there's too much myth around data privacy. So many times I speak to clients and they say, oh, we cannot do this because of data privacy laws. In fact, my own marketing team at ENS Africa, sometimes they would tell me, sorry, I can't send something to a database because of data privacy laws. And I take a step back and say, who taught you about data privacy laws to begin with? But beyond that, I think getting rid of these myths and relying on experts are essential, because so much innovation is being stifled because of myths around data privacy. And that to me is a real frustration. Just yesterday, I was with a leading massive organization in financial services, and they told me they've abandoned a number of products they were going to take to market because they were afraid of data privacy concerns. And when I looked at it, I said, but I can tell you, just looking at it from a bird's eye view, there's a number of ways which we can make your commercial objectives happen without falling foul of data privacy laws, because the laws are not there to stifle innovation. They're just there to make sure you behave responsibly when it comes to innovation. And I think for lots of businesses, getting rid of those internal myths becomes critical. And that's where training and retraining becomes important. And as much as you want to create this culture of compliance within your organizations, it's also critical that your business stakeholders are aware what they can and can't do, or to rely on experts who actually understand what the parameters are of the law, and how you can still achieve commercial objectives without falling foul of data privacy laws. And I think then the last thing is that I probably mentioned already, training still remains one of the most critical aspects for organizations. Training staff is to, not just on the basics of compliance, but also how do you achieve commercial objectives in an environment of data privacy? I think all of that becomes really critical as well. So I think that, yeah, those would be my tips at a high level. But yeah, absolutely echo everything Catherine and said. I think we've lost our chair.
Okay, so before our chair comes back, maybe I can add on. I agree with you, Ridwan. Maybe one of the things which actually should be echoed and highlighted is the issue of the differences within the African region, and the differences in, say, like in some regions there's common law, in some regions it's civil law. So the emphasis on not placing everything in one pot in terms of regulatory approach or compliance approach, because then for those of us who support businesses across Africa, you've seen how, for instance, compliance or the attitude of how things are handled within Francophone is totally different from how it's handled in West Africa versus how it's handled in East Africa. Some regions have similarities, but some are like day and night. And I think that's very important, especially for clients who have expansion plans or are going into different markets. I agree with you. And that's something that we should always emphasize for the clients to have at the back of their minds, or for businesses to have at the back of their mind. So then that emphasizes the need for local counsel who understands the local nuances. There's so many times where, for instance, I've seen people coming into the Kenyan market, and I'm sure these situations also happen, you guys can relate, where they're coming into it's a multinational coming into the Kenyan market, and it's been supported by a UK, say, law firm. And things go left when they're rolling out. And obviously it's because of the small things that we've said, market nuances. The local counsel would be able to tell you, for instance, the regulatory mindset, how to go about compliance, what to do, what not to do. These are things which you won't find written in laws. Well, you can pull out the act and say, this is what the Data Protection Act, say in Kenya says. It's totally different when it comes to the regulatory mindset, compliance, and on engagement with the client. So that's one thing that I'd highlight also for external counsel and for in-house counsel, not to assume that just because you're rolling out within Africa, the nuances are the same. Totally agree.
If I may just come in here, I think it raises another very important point for anybody sitting outside of Europe. Earlier this year, I sat on a panel and we were lawyers from all over the world except from Europe. And the single biggest common frustration amongst all lawyers across the world outside of Europe is a European company will come in, or even a US company will come in and say, we GDPR compliant, so that means we probably compliant, or we must be compliant with your local law. Sign our standard GDPR data processing agreement and everything should be fine. That's not the case. There are nuances, and understanding local legislation is important. And that is a real practical frustration which a lot of businesses are facing. It's not a South African problem, it's not an African problem. Whereas in Asia, South America, even in the Americas are also complaining a lot that seems to be the approach taken by European companies coming into the African market to say, and it doesn't help when Catherine is a great example, when they've got legal counsel sitting in London trying to advise on African issues. I think having feet on the ground and local knowledge, that's absolutely critical, and having in-country knowledge, that is critical to the success of any expansion into any specific African jurisdiction.
Wow, thank you so much for the gems. I really hope the businesses that are here are listening, because this most of the times is paid services, right? To get all the nuances that businesses need to focus on. But I think for me, what stood out from most, or at least the large chunk of the time that I've listened to you, is the need for understanding local nuances. And a good point or a good place to start from is having a network of people that you interact with in the different countries that you wish to operate in. And just to conclude, and I think this will really take a lot of time. It's unfortunate that Maha has not been able to join back. But I think we have really tried touching upon on this issue of predictions for 2024. But just to set them aside as an individual issue, I think it's good for us to run over them again. What do we think are the predictions that we have for the coming year based on everything that we have said? And this will be the final question, and we will be wrapping up and inviting any questions that we may have in the Q&A. So I'll start with you, Lamos.
Okay, perfect. Something I want to say that I didn't say before is that I think that awareness is also going to be a big thing next year. We've noticed that a lot of DPs are focusing on that or have mentioned initiatives. So a lot of those initiatives will be launching in the next year. So I think there's going to be a lot of awareness for the average user, for businesses, and maybe other stakeholders within the sector. The second thing I wanted to highlight is that I think that there's going to be more cooperation. And I mentioned this earlier. I specifically highlighted the Malabo Convention and the AFCFTA as propellers for this, fingers crossed. I'm also predicting that there will be more regulation as regards AI and emerging technologies, like we've all said. I predict that there's going to be more revision of data protection laws, primarily because of the Malabo Convention, but also to keep up with, some of the emerging technologies that we have. If countries don't pass their own individual AI laws, it would just be, wiser to incorporate that with the existing data protection laws that they have. So there might be more revision of data protection laws within the region. I foresee more enforcement, which we also mentioned. There's a flurry of new laws, there's a flurry of new DPAs, and then there are DPAs who are becoming more active this year. So we've seen some enforcement action. I'm expecting that even next year, we'll see even more enforcement action. And the final thing I mentioned is content. I foresee that content will be a big headline for next year. Yeah.
Ridwan, briefly, what are your 2024 predictions?
Sure. I think for South Africa, which is the most targeted country in the world when it comes to cybersecurity attacks, and indeed, it's not just a South African problem, it's a global problem. For South Africa, Southern Africa, the single biggest area of focus next year is going to be companies being subject to more and more hacks, and those hacks are taking place both internally from employees, disgruntled service providers, but a lot of external attacks as well. Regulators are going to need to, companies need to equip themselves to be prepared for those attacks when it happens, not if it happens, when it happens. And regulators themselves need to adopt a much more pragmatic approach to dealing with this. If you're simply going to slap every single company that comes with a hack, with a fine, it's not going to be conducive to building, a nation that has trust in its regulatory authorities. You're going to have a lot of reviews taking place, and the regulator will find themselves in a lot of matters before courts, and I don't think they've got the resources for that. So that's my first big prediction. Second, I think I don't think anything or much will happen with AI next year. I think they still just wait and see approach, but I think probably towards the end of next year we'll start seeing regulators putting in place some form of action. I think one of the reasons why privacy regulators should not be too focused on AI, because the risks around AI is much more than just data privacy. There's IP risks, there's things like robo advice and misinformation. There's a myriad of risks. So there's not meant to be a talk on AI, but the risks are much wider than the ambit of what data privacy authorities cover. And I think if data privacy authorities are going to try and focus on regulating the data privacy aspects in isolation of all of the other risks which appear, I think they're going to really make a bit of a mess of things. It's good to put in place codes of practices around, ethical data capturing, usage, training of large language models and the like. But trying to over-regulate too much in the data privacy space, I think that's going to become a big problem if regulators, tend to push the boundaries of what the actual ambit is. The other prediction, as I mentioned, a number of countries are enacting laws, and towards the end of next year, I think we'll see quite a few countries in Southern Africa having laws. Namibia, Botswana, Zambia, all of them should have active laws by early 2025 or so. So that's another trend which I'm predicting.
Oh, thank you so much. Catherine?
I agree with Ridwan's and Ilamos's predictions for next year, which are similar predictions. For sure, I expect that the 14 or so countries that don't have data protection laws, because of the Malabo Convention coming into place, for sure, there will be more push and more pressure on them to enact laws. I expect to see a lot of activity around the AU Africa Union after Malabo Convention, the framework on data protection and privacy. Data protection framework, I expect to see a lot more engagement from a regional perspective. I expect to see global trends also affecting our regional market as well, because of the trade inflows and things like that and how we operate. So I expect that we shall not, in terms of emerging technologies, we shall continue to be affected by technologies that are disrupting our various sectors. For the regulators, I expect them, because I think most regulators in the African market can be said to be in what is called the formative stages. So I expect that next year, some of them will be shifting into the next stage, for instance, applying themselves more into the different sectors and how the different sectors are affected by the data protection laws, for instance, addressing themselves to the health sector. I think in Kenya, for us, we saw a lot of, we saw our regulator doing that. For instance, they had a case where they addressed themselves to education sector. There was a penalty, there was a fine that was issued to a school, which meant they addressed themselves on how the laws affect, say, schools. There was a club that also got a penalty in Kenya. So we've been seeing them addressing themselves and issuing guidelines on, say, financial services. So they gave guidelines on financial services and on different sectors. So I expect them to now show capacity and up their skills, because in attempting to do so, one of the things that our regulator, I think, tried to do is to hire more people, more skilled people, so that, and then we saw their office growing and their capacity growing. So I expect to see that, more of that around Africa. And then the other highlights that they said. So that's what I predict mostly. So the regional engagement and the data protection authorities being challenged, so to speak, to deal with the emerging issues and to deal with the whole agility, as Ridwan has said. I think they'll be challenged more and more to be agile and to make pronouncements on some of these things. So for instance, like in the World Coin Cane that Ilamosi mentioned, they had ticked all the boxes. The controller, they had registered, they had done that, but the regulator had not addressed itself on some of the things that, from a citizen perspective or public interest perspective, because the matter was argued from a public interest perspective that you can tick all these boxes, but you can't come and tick biometrics of citizens. And what are you doing with that data? So the regulator had to pronounce itself on that after the parliament. There was a lot of pressure on parliament on this from a public interest angle. I predict that also, I think they will join the South African peers by more scrutiny on governments and keeping governments more accountable. I don't think it will be widespread, but I expect to see one or two more regulators or authorities trying to do that. And I think part of the reason why we haven't seen a lot of activity in that sense is the fact that I said the independence. I think most data protection authorities were the brainchild, or rather, you'll find they were being housed, like in Kenya, they were being housed by under the ministry. So then they are what can be called a government entity. So it was a bit hard for them to exercise independence. And I think that this is replicated around Africa, where despite the fact that on paper it says that they should be independent, it was hard to exercise that independence and really also scrutinize or put a magnifying glass on the activities of the government or the public entities. But I expect that now, as they grow and more, to see at least 2 or 3 more or 4 more next year, trying to keep governments accountable as well.
Wow, thank you. Thank you so much, guys, for your interventions. We are I see time is almost over, but I wouldn't want to end this conversation without addressing 1 or 2 questions. So I see from our chat we have 2 questions. I will give each of our panelists literally half a second to address these questions, and I think I'll start with Catherine, and then the other one I'll separate it between Ilamosi and Ridwan, because the first one is specifically addressed to Catherine. So Catherine, can you highlight some of the bold judicial decisions in East Africa? So if you can, maybe summarize or give us one in the shortest time possible.
I'll do it quickly. So most of
Okay.
the bold decisions we've seen out of East Africa are from Kenya, and understandably so, because the Kenya Data Protection Authority was formed before the Tanzanian, the Ugandan, and the other countries, and the Rwandan one. So then they have the benefit of being a bit ahead in terms of advancing. So the bold ones that we've said, in fact, I've mentioned them here, is the decisions on pronouncing themselves in the different sectors. When our regulator started, it was going for more of what we call the low-hanging fruit, the entities that process, which would be called the entities that process data on a large scale, the obvious ones like financial institutions, so the banks. Those are the ones that our authority was going after in terms of audits and scrutinizing what they're doing. But this year they had a different approach, and I think the last one that they released, there were 3 entities were penalized for, I think, over cumulative amount was over 9 million. As I said, a school. So we saw a school being penalized. We saw a club being penalized. And Mercy, you can help me, Kenyan. Who was the other one that we saw a significant penalty this year?
Against fintech companies.
Against a fintech company. So I'd say within East Africa, the Kenyan Data Protection Authority has been making those bold moves, and we're looking at the other East African regulators to see what they're going to do. But given they're in different stages, before a regulator got to this place where they can now address this, they were in the setting up stage. So I think they were more focused on registration and things like that, but now they're in the next stage. So we're waiting to see activity, and I expect to see a lot of activity from the other East African countries next year.
Yeah, thank you so much. So the other one, I'll be able to only address this one last time because of time, touches on data transfers. And the question is, how can we foster an intra-African free flow of data for innovation? So Ilamosi, if you can handle that, and Ridwan. The other one, so part of the other question is, how, in your views, should we balance protection of privacy and access and sharing of data for innovation? And partly also answer the question on how to reduce the cost of compliance while ensuring protection of privacy. So 2 for you and 1 for Ilamosi, and then we will be done.
Right, I'll try and keep this as brief as possible. I think that for cross-border data flows or cross-border data transfers, the best way to facilitate that would be advocacy. You need some level of cooperation amongst, data protection authorities, governments, and that can only happen if there's some level of advocacy. So I would say that we should participate more in conversations about cross-border data flows. If the AU is calling for comments, if you can speak to like your local government representative, anybody that you have contacts with, I think that's a good way for average citizens to participate. As other stakeholders and companies, like if you're a CSO, for example, I think getting into those rooms where those discussions are being had and just weighing in, I think is a very good way to participate. I also think that if you're a company, sending in comments, making sure that you join pressure groups that can push your comments forward is also a good way to, make sure that the change that we want to see happens. So I think advocacy is the basic answer, because we need cooperation, and that's not going to happen without, all the parties coming to the table and everybody sort of bringing them to the table and bringing in their own different opinions. So advocacy, just short, simple answer.
Thanks so much. Ridwan.
Okay, I'll answer the first question very briefly. So how should we balance protection of privacy and access and sharing of data for innovation? I think if we look at most privacy laws, it gives you, in South Africa, certainly there's 6 grounds for actually processing of personal information, consent being one of these grounds only. And I think having a deeper understanding of all of the other grounds, that's critical towards actually understanding how much you can and cannot do with data for innovation purposes. As I keep on emphasizing, I'm a commercial lawyer. Most of my work, my initial work in data privacy was on compliance, what should companies do to comply. But these days, most of my work is around data commercialization and monetization. And how do we actually, in a regulated environment, still achieve things like innovation, still achieve things like data sharing, etc. As I said, data laws are not meant to prevent businesses from operating. They're there to make sure that businesses operate in a responsible manner when it comes to respecting the rights of privacy of citizens. And there's a number of ways in which this can be done. Obviously, it's always, as a typical lawyer's answer, it depends on the circumstances, but it can be done. And data privacy laws are not meant to frustrate innovation at all. And any data privacy lawyer who tells you can't do certain things, they may be, yes, they can't do certain things, but always question why. Don't take it for granted that because you have this thing called a data privacy law that you can't do things with data. There's a lot you can do with data. You can use it for innovation, you can access it, you can share it, but there's manners in which you, or there's mechanisms which you would have to employ to actually do that. And speaking to somebody who's skilled enough commercial lawyer with a data privacy focus should be able to help you with your real business requirement. And then very lastly, the last question, how do you reduce the cost of compliance while ensuring protection of privacy? At ENS, many years ago, I developed something called, our act is called POPI. I developed what's called a POPI compliance toolkit. And it was actually meant to be a relatively low-cost solution for businesses to fast-track implementation of data privacy laws. Rather than having 100 companies develop policies on their own, what we decided, we created a set of model policies, training material, and a few other tools, and made it available at a reasonable fee for clients so that they could fast track their adoption of data privacy laws. But I think regulators also have a strong role to play here. So regulators should actually be putting out things like model privacy policies, model consent clauses, training material for staff, etc. As long as if regulators take that proactive stance, then all companies need to do is really then take that next step of implementation and change management, which is another important aspect. And I think that will help reduce the cost of compliance significantly. So it's both sides. Number one, looking for quick wins, and experienced lawyers can help you achieve those quick wins. But number two, regulators also have a very strong role to play to make sure they bring down the cost of compliance. And I do believe it is achievable, rather than leave companies to themselves to figure out how to comply, what to put in place. I think regulators can provide that advice quite effectively as well. And that way you're sure that you're actually not falling foul of legislation. So two quick answers to questions from me.
Mercy, if I could add to Ridwan's thing. Yeah, so I agree with you, Ridwan. And I always tell my clients, compliance is not one size fits all. And once you know that from the beginning, and then I think on the cost of compliance, I'd also like to add, there's a phased out approach, which you can always adopt. And one thing which we've noted for, and I'm sure it's the same for you, Ridwan, for the clients that we support, there's no client who gets penalized because they did something. Most likely, because they did something towards compliance. Most likely, the regulator will come and say, tweak your privacy policy, tweak this to sort this. But if you don't have a privacy policy to start with, that's where the problem lies. And that's how people end up on the penalty side of things. So always say, start somewhere and make compliance an ongoing engagement. The problem with most people is that they approach data protection compliance as a tick box exercise. Checklist, place this, place that. But as long as you keep doing the active regulatory exchange, then it makes all the difference, and you manage to stay away from penalties and harsh regulatory actions. So basically, it's the approach that really matters.
Fully agree with that. Yeah.
Wow. I think I also agree with you, Catherine, on that one. And I think it's a good point to end this conversation, and also to think about what data protection really should achieve for the continent, because, and Ridwan, I think, and Ilamusi and Catherine, you've also emphasized is that data protection laws, their end goal is to promote business operations and really not to stifle them, right? And I see we have one other question. I don't know if and it's actually addressed to Ridwan, so I'll give you literally less than a minute. So this question they ask, hi Ridwan, can you shed more light on your stance against DPAs regulating the privacy aspect of AI? What do you propose then? So literally half a second, half a minute.
So I'm not averse to DPAs regulating privacy aspects, but I think they should, rather than regulate it, is rather provide guidance. Why I say they should not regulate, because if you look at the legal risks around artificial intelligence, data privacy is one of a number of legal risks. There's things like the risk of intellectual property infringement, which is very different to data privacy. there's things like the risk of incorrect advice, which may put you in place or in breach of other regulations. And like that, there's a whole myriad of risks. I do a talk on artificial intelligence, and there's literally 10 legal areas or issues which emanate, data privacy being only one of the 10. So if DPAs overextend themselves with regulation, they may find that they actually trampling on or they're trying to regulate things which are outside of the ambit of their expertise. Alternatively, what they may inadvertently do is ignore other risks and make it seem like if you satisfy these data privacy risks, you're good to go with artificial intelligence, meanwhile ignoring all of the other legal risks that actually arise from artificial intelligence. So that's a quick answer. So not averse to regulators putting out guidance notes around AI, but I still don't believe that DPA or data protection authorities are the correct body to regulate AI in broader terms when it comes to all of the other risks.
Thank you so much. So in summary, data protection is only one aspect of the entire AI debate, important, but you also need to consider other forms of what kind of regulation we require. So unfortunately, we have come to the end of our webinar, and I wouldn't want us to end this session without thanking our partners. So we have this webinar has gladly been sponsored by Privacy Officers Africa, which Ridwan acts in the capacity of a director in there. Ikaranj, a partner of Tech Advisory, and I think at this point it's also important to mention that there will also be another webinar focusing on Francophone Africa, on privacy developments that have been notable in Francophone Africa. So if you're interested in privacy and data protection developments in Francophone, be sure to check out the registration for that on 16th December. We also want to thank Privacy Lens Africa.
Seems like our chair is frozen. Okay, I think we are wrapping up. So from my side, thank you very much for having me here today. Catherine, Ilamosi, Mercy, and I really have learned a lot from you today, and I really appreciate the interaction and the discussion today. Thank you very much. It's been great.
Yeah, I think from my end as well, I think it was quite thought-provoking, and it was nice to have you, Ridwan, Mosi, and Mercy, and even the participants. I think the questions were thought-provoking and very insightful. I think all of us will go back to our notebooks. Definitely. Yeah, we've learned a lot, but yeah, it was such a pleasure, and have a good one.
Same.
It's a public holiday in Kenya.
It is.
Yeah, it's Independence Day in Kenya.
Well, thank you for joining, and it was a pleasure speaking with both of you and meeting both of you and hearing and exchanging ideas.
All right, I'll just close it out. I don't know exactly why Messi is off, but I'm guessing no load shedding. Well, thank you, everyone. Thank you.
Nasty joke.
Thank you, Lamosi. Thank you, Catherine, and to all everyone who attended and stayed back. We really appreciate it. It's just start of the conversation. Our report is coming out. It's later at the end of the year, and we'll keep the conversation going. We can all enjoy the rest of